This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everyone. I am Stuart Address, and I don't just play one on the radio. I'm a real lawyer. Good Friday. Happy Passover. And you know that little blurb you always hear in front of the show? You know, the opinions and blah, 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 blah. Guess what? A lawyer wrote that. Not me, but some lawyer somewhere
A long
paid
time ago.
to write that. That's so that people don't get sued. Well, guess what? We have a little something special for you this morning. The best caller of the hour.
Ooh.
Oh, get your
Wish I had
fingers
like
ready.
applause or sound effects.
Those rotary phones, get those fingers ready.
Put us on your speed dial. That's another radio cliche.
The best call of the day will get a $25 gift certificate to the St. Lucie Draft House.
So how are we going to do that best caller of the day? What we'll do is we will take their name and number. We'll hear their story or their comment. And at the end of the show, you're going to pick.
At the end of the show, I will pick. And I have a funny feeling if it happens, there will be one person that will be ineligible. Don't worry, Bulldog, I'm not talking about you.
Yeah, he'd have a long way to go to come and pick up his prize.
All right. Well, we have, dual religious holidays this weekend. So hope everybody has a good holiday. And I hope you maybe are off of work and have some questions in store. Remember, you can call on any topic. Recently, we've been talking about overtime. We've talked about non-compete agreements. I keep promising you we're going to go into sexual harassment. And I just figured today I would start out with a couple little, tidbits. You know, Cliff always says, get ready to rumble. I love that, really, I do. So let me tell you a couple rumbles that have actually occurred in court.
Okay.
With me. I had a federal trial on a sexual harassment case a while years back. And one of the witnesses that the other side was going to call, the employer's side, I happen to have known had a couple of very salacious prior convictions. And there are some very specific rules about how you can deal with that. And essentially, you're only allowed to ask a witness, have you ever been convicted of a felony or a crime involving truth or dishonesty? If they answer correctly, you can say how many. And if they answer correctly to that, you're done. The jury doesn't get to hear what they've been convicted of. However, if they screw up on either of those questions, you get to introduce certified copies of their convictions, which includes what they did. And sometimes that could affect a jury's impression of their credibility. Well, in this trial, because it was so salacious, we excused the jury before that witness was called. And I said to the judge, Judge, Mr. Chief Judge at the time for the Federal District, Southern District of Florida, something's about to happen. And I just want to get everything lined up, all the ducks in a row, make sure I do it the way you want me to do it. Mm-hmm. I said, we're about to have a witness called who's been convicted of a couple of felonies. And I said, my understanding, I'm going to ask him, have you ever been convicted of a felony or crime involving truth or dishonesty? If he says yes, I'll say how many. If he gives me the right answer, I'm done. If he says the wrong answer to either of them, I'm going to introduce the certified copies of conviction. He says that's fine. Jury comes back in.
So what you're saying is a possibility that this person would lie?
Yes.
Okay.
It happens all the time. And so I say to him, have you ever been convicted of a crime, of a felony or a crime involving truth or dishonesty? And he says, yes. Not the answer I'd love to hear, but okay. Still helps me in front of the jury. And then I said, well, how many? And he gives me the wrong answer.
Uh-oh.
So I said, well, isn't it true that you've been convicted twice on lewd and lascivious on a minor under the age of 12? And all heck broke loose. The judge is yelling, I'm going to hold you in contempt. You're not supposed to be doing that. You know, deputy, remove the jury. Jury leaves. I said, Judge, I said, we went through this just before. I can hold this call. Trust me, I know why.
Okay.
We went through this just before we called the witness. He says, no, I never said you could do that. I said, Judge, I think maybe you should have your court reporter, in chambers, go back and read you the
read
transcript.
back what you said.
He says, that's not true. And at the end of this trial, we're going to have a hearing on order to show cause why I shouldn't hold you in contempt. So we take a little break. He obviously gets it read back to him. And he comes back and he says, well, let's bring the jury back in. I said, whoa, wait a second, Judge. We've got to resolve this. The judge says, let's just move along. Now, that's as close to an apology as you're ever going to get from a federal judge. Okay? I said, well, Judge.
You should just, for the record.
we need to at least tell the jury that I didn't do anything wrong,
right,
because they're left with an impression.
Yeah, now they're thinking you're a bad guy.
He says, no, we're not going to instruct the jury. I said, well, at least tell my client that I didn't do anything wrong. He says, let's just move on, Mr. Address. So we moved on. But yes, that was a rumble. And if we have time, I'll tell you another rumble. But we do have a call. We have a call from Bubby on line 1. Go ahead, Bubby. Bubby, you there?
Oh, we are in delay, and they are there. There we go. You need to, Bubby. You need to listen on the phone and not on your radio because we are in delay.
Yes, this Bubby would make that kind of mistake.
No, she wouldn't.
Well, Bubby, what's your question?
Okay, although you've touched on this subject before, now it concerns me, so I would appreciate you speaking about it again. My granddaughter is graduating from university this May and was lucky enough to get a lovely job in her field, which is event planning. My question is, she was told her job would be 32 hours for sure, but could be 50 hours. Will she get time and a half after 40 hours?
Well, Bubby, let me ask you this question. Are you asking about U.S. law or Canadian law?
U.S. law.
U.S. law. Okay, Bubby. Well, generally, if she's a non-exempt employee, then she is entitled to time and a half over 40. If she's exempt, she's not. From the facts that you haven't told me, but that I know, I think she's non-exempt and she should get time over 40. And by the way, folks, the reason I know so much about this is a pretend caller. This is a caller making believe they are a real caller. This is a caller that will not be eligible for the $25 gift certificate to the St. Lucie Draft House. This is Bubby, my mother. Hello, Mom.
You're doing a great job, my son.
Thank you. That's what a mother is supposed to say. And by the way, in preparation for what I thought was going to be your call, I have a further answer for you.
Okay.
Under federal Canadian law, you are also entitled to time and a half for hours over 40. But guess what? Unlike American law, if you work more than 8 hours a day, you're also entitled to time and a half. So if you work 10 hours one day and 12 hours another day, that's 6 hours over the 8. If you work 43 hours in that week, you don't get 3 hours of overtime. You get 6 hours of overtime.
Oh, that's wonderful. That's great to know.
So go call Gwen and let her know. But I'm going to tell you that her 2 kids, who are extremely intelligent, I guarantee you they're exempt.
I will find out, and I will let you know.
Goodbye, Bubby.
Continue on your wonderful program.
Bye-bye.
Love you.
Love
Bye-bye.
you too. Oh, well. Nice way to start the morning. I had a feeling she might do something like that today. So, we were finishing up last week with non-competition agreements. That's how a mother can really throw you off kilter.
Yeah.
And I just, we were sort of done, and I just want to do a little bit of a 5-minute review on a couple of things. If you get an agreement, whether it's a part of starting a job, in the middle of a job, or just before they're about to let you go, or you've told them you're going to go, that has anything about restricting your ability to compete, be careful. Read it carefully. It may be well worth your while to check with a lawyer, because these agreements are highly enforceable in Florida, and unless they are beyond either time duration or geographical scope, you're going to be stuck with them. And the first thing a nasty employer is going to do once you get your new job is have a lawyer send a nasty letter to you and your new employer. And if you're not a really, really valuable employee, that new employer is going to let you go too.
Mm-hmm.
And even if that new employer doesn't let you go, if that non-compete agreement looks like it's solid, a judge is going to enter a preliminary injunction against you, and you won't be able to work for that new employer until the case is over 2 years from now, by which time you probably won't have a job anyway.
Or a house.
Right.
Or that
So,
car you're
you're
making
right.
a payment on.
And people call and they say to me, well, this is going to destroy me.
Mm-hmm.
And I have to tell them that not only doesn't the judge care, the judge is told by Florida statute you're not allowed to care. And the Florida statute, individual hardship cannot even be heard by the judge. You start to tell a judge about it, he or she is going to shut you down.
Mm-hmm.
And it's not because they're nasty, it's because Florida statute has said that's the way it is. Now, there are ways to deal with non-competes, but they are a dangerous thing. They're common in a lot of industries, but they can be very dangerous. I've had a good number of clients come to me, and we either have to try to negotiate an early termination to a non-compete agreement, if I've determined it's really valid, or we have to try to, threaten our own litigation based upon it being, too long or too large a geographic scope. But I really, there are not a lot of big warnings I give to people, but when it comes to non-competes, be wary, be double wary, be triple wary. And if you're an employer out there and you don't use them, well, you may be a good guy, but from a business perspective, it may not be a smart thing to do.
Mm-hmm.
All right. So if you have a question about it, feel free to call anytime. But we are going to have another little sort of short segue.
Let's throw the phone number out, 340-1590.
All right, 1590. And by the way, that violates Cliff's rules. It's not one digit at a time. You just gave 4 digits at a time, 1590. So it's 1590. That's right. There's no 1590 on the keypad. All right, so let's talk briefly, and I think it will be relatively briefly unless we get 10 calls, and I hope we do. Let's talk a little bit about small claims court and county court. Because a lot of cases are in that smaller area. Small claims court in Florida deals with cases that are $5,000 or less. And county court deals with cases that are $5,000 to $15,000. After that, you go into circuit court. Now, small claims court is designed to be unintimidating to the average person.
Mm-hmm. In other words, you can pretty much handle it yourself.
Well, for the most part. Depends upon how complicated your fact pattern is. But for the most part, yes, it is designed that way. And there are a lot of people that call and they want a lawyer to represent them on a small claims case. And I give them I give them 3 pieces of advice. 1, you may be able to do it yourself. 2, if you want, feel free to come in for a consultation, and maybe that's all you'll have to pay me, and I can walk through how you can handle it for yourself. Or 3, if you really are determined to get a lawyer, there are lawyers that handle small claims court cases as a matter of their regular practice, and they'll go in and they'll have 15 or 20 of them on any given small claims court day, and you'll get charged a lot less than if you hire somebody like me.
Yeah, I was thinking, though, because it's a small claim,
Yes.
it would be a small case, a small payment.
And if you're an attorney that is in court on 15 or 20 of them, it may
Okay.
very well be.
It's a day's work
Economy
then.
of scale.
Okay.
But if you call somebody like me and I have to go to court just for you, it's not cost
You're kind of doing me a favor.
Right. Anyway, we have Deborah on, I think that's line whatever. It looks
Yeah,
like line 7.
I got her.
Line 1. Okay. Hi, Deborah.
Good morning. How are you?
I'm doing good. How can I help you?
Okay, my question is more for my husband who's trying to file for a disability claim.
Okay.
And due to diabetes, he had to have both legs amputated below the knee.
That's a shame. I have an insulin pump, but I hope I don't get to that point. It's unfortunate.
Yeah, sure. Take care of yourself. But my question is, they're telling him it takes a year and a half to go in front of a judge to...
Has he filed
final
the
decree.
disability claim on his own or with an attorney?
Twice he filed.
On his own or through an attorney?
on his own.
Yeah, unfortunately, the limited amount that I do know about disability claims is that they can take forever and a day. When my office does get calls like this, we usually, refer it to 2 or 3, attorneys that do disability law. It seems that the lawyers that handle disability cases seem to know how to work the system a little bit and get it handled a little bit more quickly. And also, obviously, they may not step into some of the landmines that exist, for the average person. But as far as I know, it does take a good long time to process and to finalize a disability claim. But if you have any, detailed questions that I honestly can't answer for you, I would suggest that you call one of those lawyers that, advertise that they do disability law. They're in the phone book. You can Google them. And frankly, better than that even, I would say, depending upon if you're in St. Lucie County, call the St. Lucie County Bar Association. Bar Association can direct you. They won't give you one name because then they're playing favorites, but they'll give you 2 or 3 names of possible people that might be able to speak to you and give you a little bit of advice.
Okay, good enough. I just couldn't believe it takes that long, so I wanted to check and make sure.
Yeah, unfortunately, it really does. It shouldn't. It really shouldn't. But we don't have enough judges anywhere. We don't have enough judges in regular courts. We don't have enough federal judges, administrative law judges. It's all a matter of budgetary policies.
Okay, gotcha. Well, thank you very much.
You're
for that
welcome.
answer.
Good
and
luck.
of course, we're going to keep your name in for
We
the
will.
best call of the day.
Absolutely.
So-
All right, thank you guys. Have a good
Take
day.
care.
340-1590. If you have a question or comment, give us a call.
So, in terms of small claims court, the clerk even has a small claims packet. And you can actually get that packet online on Google or at the clerk's website.
Mm-hmm.
And the packet is relatively simple. You start out with what's called a statement of claim. It's a 1-page document. It says, I, whoever you are, sue whoever I'm suing for and an amount, and a few lines to briefly explain why you're
What
suing
it is, yeah.
somebody.
Mhm.
And then there is a filing fee. It gets higher the closer you get to that $5,000 mark. So there's a sliding scale. And then once you file your case, let's say you're doing it without an attorney, you file your case, you're going to give the clerk, it's all in the packet, self-addressed stamped envelopes for you and for the defendant. And a week or 2 later, you're going to get back what's called a pretrial order. And that pretrial order is going to tell you both to appear at the courthouse on this date at this time. Now, it's going to tell you that your case will not be tried at that time. And that confuses a lot of people. They show up with all their stuff ready for trial.
Mm-hmm.
Cases do not get tried on the pretrial date. What happens is you go into the judge's courtroom, and I've been in front of these small claims court judges in a number of counties. They are usually really nice. I mean, they know that most people are there without lawyers. And they explain the process very well, very clearly to everybody. And essentially what they're telling you is, this is a pretrial date. I'm going to call the case, I'll call the docket. If you're here, say you're here. If the plaintiff isn't here, we're dismissing the case. If the defendant isn't here, you win by default. And if you're both here, we're going to send you to one of these lovely people in the jury box, an attorney who has volunteered his time for the day, and you're going to talk to him or her in a private room, and you're going to have a mediation. And that attorney is going to try to help you to come to some agreement. And if you can come to an agreement, it'll be written up. You'll come back before me, the judge. I'll enter a judgment. And if it's followed through on, then everything's great. If it's not, you'll have to come back. If you don't come to an agreement, then you let us know, and you're going to get another thing in the mail in a couple weeks, and that's going to be a trial date. And then you come with whatever it is that you want to use for trial. Now, what's a trial in small claims court like? There are exceptions, especially if you have a lawyer. But for the most part, trials are like 15-minute. They're not quite like Judge Judy. The judge usually isn't as nasty as Judge Judy, but they are essentially what Judge Judy portrays. You tell your story, the other side tells their story. If you have documents, the judge looks at the documents, looks at the other side's documents, and comes to an opinion based upon gut instinct. Gut instinct is enough for the preponderance of the evidence, 50% and a feather, and that's the side that wins. So I think we have a call?
We have Bulldog on the line.
We have Bulldog. Okay, Bulldog,
and he
how you doing?
understands that he can't spend his gift certificate, so he's just calling with a good comment.
All right. Why, is Bulldog far away? He never told me that.
Yeah, Palm Coast.
Palm Coast. When I was working in Daytona, I thought about moving to Palm Coast.
No, if I win, I want to donate it to G and Paul.
Yeah, they can't win though.
Well, no, but I can win and donate it to them.
They're exempt.
I don't know. We may have to look at the fine print.
Yeah.
Yeah, hey, lawyer man.
No,
Step in here and tell me.
It's any employees or relatives of those employees can't win any prizes at this radio
how are
station or
relatives
any
defined?
other radio station.
How are relatives defined?
Anybody who's related to anybody who works here.
By what degree?
No, I don't really do. We're not that strict with the rules here, but that's usually what it is with the radio station.
All right, Bulldog, how can I help you?
Yeah, I just want to. Hey, look, this is not coming out of left field, so I'm
Right
on
field?
something. No, well, on base. Basically, you opened with a sexual harassment, and I wanted to ask your opinion
That was
on
a tease.
a certain story, written by one of my newspaper guys up here, editorial that said, well, I sent female reporters to Bike Week, and they got sexually harassed, and Bike Week should be eliminated, and all this. And I'm like going, then why
No.
go?
There's no sexual harassment at Bike
What is
Week.
the definition of harassment? What did you say, nice butt or something, guy? I mean, it's gone over the edge with that, I mean,
I'm not sure that would qualify, frankly.
Right, of course. But, he claims it, and he's an editor. And
Well, I
all
guess
this
if
fun-
you assign someone to cover that particular event, you're sending someone who may not voluntarily want to be, called sweetie
You're
or
right. And so, like in everything in law, there may be a claim. But essentially, all of Title VII discrimination claims, which include sexual harassment, are protections for employees against essentially co-employees and supervisors, not customers, or in this case, miscreants.
Okay.
Okay? Now, there are exceptions.
Hey, what's that miscreant thing? I caught that. No.
I thought I'd slide it by.
No.
Anyway,
No.
but there are exceptions, and if you happen to know that somebody is going to be put in a position where they're going to be abused, and you knowingly do it, and they've objected to you, you may have some culpability.
Now, that is good. But, like I've always said, is I've had employees that say, I think I was sexually harassed. And I said, how long? And if they go back a month, and I said, did you go to HR?
Good
Have
question.
you told anybody, I mean, excuse me, but there are limitations of some sort on this, and you can't just retrospect this thing back into, now I hate you or whatever.
You're right, and we're going to go into the exception to that rule, and we're going to discuss that rule as well, because you're right. There is a rule about having to complain, and then there's a little exception, which is swallowing up the rule of late, just because of the nature of what's happening in society.
I say suck it up, soldier.
But there are also cases. For example, there's a Hooters case.
You go, Veronica. You go, girl.
There is a
if
case.
you don't like it, walk out.
That's right.
Well, hey, as a plaintiff's attorney, as an employee's attorney, I don't quite go that far. I'm a little bit more liberal.
Well, I've been to Bike Week.
Well, okay. There is a case, an early case, many years ago, involving Hooters, where one of the waitresses complained that she was being sexually harassed. And what was the sexual harassment? It was, grabbing, touching, remarks by customers. and it went up to the good old Supreme Court of the United States.
She didn't know that when she took the job.
Well, that's what the Supreme Court said.
Okay.
There are rules, but there are also situations that if you voluntarily put yourself into them, the rules are a little bit flexible. And while it's not everything goes, even at Hooters.
Right.
But there are certain things, given the nature of the position, that are more considered acceptable or not unlawful, whereas in another office environment, they would be considered unlawful.
Mm-hmm.
So, everything is all about the facts.
See, but at that moment when that slap on the rear end or whatever happened, she needed to correct that right there.
Well, that's true.
And, her
a lot of them are
boss-
trained
Yeah,
to do
her
that.
boss probably would back her.
Yes, most of them.
So, if
And
you
see, that's-
address it,
Yeah,
that's it.
exactly. That's just like Bike Week. There's one in every crowd.
There's
And
more
it's
than
gonna
one in every
happen,
crowd.
And kick them out and say, "You did this, he's gone."
Remember,
Okay.
I used to live in Daytona Beach, so I was there for Bike Week and Biketoberfest.
Oh,
and
yeah.
There's
Oh,
more
yeah.
than one in every crowd.
Yes, but that's what we go there for.
I know. Except the traffic is horrific.
Yeah, no, it's
Yeah,
bad.
Boot Hill Saloon's a nice
I
place
do
to
know
go.
that saloon, yes.
Oh yeah, beautiful.
Smallest bathroom on the planet.
But
The longest line too.
Yes.
Exactly.
your point is well taken. For the most part, I agree with it, but there are exceptions and there's some flexibility there.
But but in a corporate workplace, you're talking differentials here, because you're talking, more how you relate with those people on a daily basis, and that could be sexual intimidation or sexual harassment at any stretch. I've had to deal with it, and a few people. Like a stalking case,
A stalking case in an employment context?
Yeah. This woman claimed that one of my employees was stalking her,
Okay.
and following her around and things like that. So that in itself is a part of sexual harassment now, as far as I know.
It can be, but that in and of itself probably wouldn't rise to
that
the level.
takes creepy to a whole new level.
Right. I mean, sexual harassment usually has to be verbal, brushing up, physical contact, or a request or a threat that if you don't comply with something, you're going to suffer adverse employment action. The leering stares, they usually don't qualify. At least most plaintiffs' attorneys don't want to take a case like that.
Right.
You know,
But
it's-
what is the? Would you define the verbal? Because that gets into a whole nother can of worms. There can be, certain things you can say like, "Hey, babe," or whatever to your secretary. Is that sexual harassment?
Then you're going to start going into intent. Every case is going to be decided on facts. If that has been the way that you have colloquially addressed her for 2 years without any objection, and now she's been fired because she stole $50 from the petty cash, and she files a sexual harassment claim over being called babe, it doesn't stand a chance in my opinion. On the other hand, you can hire somebody, and start calling them babe, and they object right away, and then you do a second thing, because usually it takes at least 2 acts within a discrete period of time.
Wouldn't you then just say, you know what, I don't like when you call me that. Could you use my name, please?
Yes, but that doesn't always work, and that's
Okay.
the problem.
But now what if this person calls everybody babe?
Then he may be an equal opportunity sexual harasser. Now, here's the kicker. If he calls the women babe and the men babe, guess what? It's
They all have a case.
It's not sexual harassment,
Okay.
and it's not gender discrimination.
I don't want to go there.
And it's not even gender discrimination,
Okay.
because it's equal opportunity.
Okay.
And there
I
are
don't
people.
even want to go there. Okay, I'll just let you go now.
I think you're going to call me back when we start talking about sexual harassment.
All right, I'll talk to you.
All right,
Thanks,
take care,
guys.
Bulldog. Thank you.
Bye.
All right. So, reverting again, I try to stay on track. I love the phone calls, but
Yep.
I try to remember where I was.
Okay.
So you go into trial for your small claims action. And it's really a matter of he said, she said, and a judge's instinct as to who's telling the truth.
Because they've heard it all before.
They have, not always, but they've heard most versions of it before. So then why bother even having a consultation with a lawyer? Some people need some structure as to how to present their version of the facts and how to present evidence. Or they PO the judge. I don't know if I can say the other word on radio.
I think so, but
they PO the judge, and they never really get a chance to be heard, and the judge is already irritated at them. So a lot of times people will come in, and they'll leave my office, with a bullet point list. All right, here's the evidence you have. Here's what you want to make sure you present to the judge. Here are the things you want to say as to why these documents are important. Here's how you want to present your facts. Don't start out by calling the other person a thief. Take the emotion out of it. I don't know if any of you remember the old
that would
version.
Be hard for me.
The old version of Dragnet. Just the facts, ma'am. Just the facts. It was, I think, Sergeant Joe Friday. Was it Officer Joe Friday? I don't remember anymore.
Yeah.
But you want to be perceived by the judge in that 10, 15 minutes as the logical, calm, white hat. Let the other person get histrionic on them because they'll lose. And then if the facts do get a little bit convoluted, and they can, even in a $5,000 case, and you need a lawyer, there are those lawyers, like I say, that do that regularly. Also, in small claims court, you can bring a friend. Sort of like that TV show, I'm going to call a friend.
Call a friend.
You can bring a friend, and that friend can actually speak to the judge. It doesn't have to be a member of the bar. That's an exception in small claims court. So,
but doesn't that judge want to know why your friend's here and why?
Because they can better explain what I have trouble explaining. Judge.
Okay.
It's common.
Now, do you have to prove why you are asking for the dollar amount?
Oh, sure, absolutely. Okay. You have to prove, just like in any case, liability, and then assuming you prove liability, you have to prove your damages. And you may be able to partially prove your damages. You may not be able to prove them at all, in which case you can win on liability and get zero in damages because you didn't prove it. So you forgot to bring in the estimate. You forgot to bring in the check that showed how much you paid. You're not coming back another day. That was your day in court.
Right.
And that's why sometimes you want to get organized before you go in. Now, what is the essential difference between small claims court and county civil court? Other than small claims court being $5,000 and under, and county civil being $5 to $15, which doesn't sound like that big of a difference, the difference is night and day. First of all, county court now starts to use the normal Florida rules of civil procedure, whereas small claims court doesn't. Once you get to county civil court, you start doing things called discovery, interrogatories, requests for documents.
Sounds like I need
subpoenas,
a lawyer.
Requests for admissions, depositions. It sounds like you need a lawyer. And in fact, while you're allowed to represent yourself, you can't have a friend come in on your behalf.
Okay.
And if you are a corporation or a business entity, you have to have a lawyer because corporations are not people. I mean, they're people in certain legal senses, and they're not people in other legal senses. They're not people for the purpose of appearing in court. In small claims court, a corporation can appear without a lawyer. County civil, now you got to get a lawyer. So it does get more complicated, and so now you reach the problem here. I think it's a real big problem. Between $5,000 and $15,000 in county court, how do you get a lawyer who can handle the matter for you cost effectively so that even if you win your $15,000, you haven't paid that lawyer $12,000 in attorney's fees?
Right.
It's hard. There have been articles that have come out in the American Bar Journal about how difficult it is to try, even in circuit court, any business case under $100,000 effectively, unless there's an attorney's fees provision in a contract or in a statute. But if you're not expecting to get your fees back as part of some statute or contract arrangement, how do you do it effectively without most of the money going to the lawyer? And you have to make tough decisions up front with your lawyer. You have to decide, am I going to have my lawyer look under every rock? Or am I going to take a chance and let some rocks go without being checked?
Mm-hmm.
Am I going to have him take every deposition? Or am I just going to pick the few I think are the most critical? And that is the only way you can effectively litigate a county civil court case. Lawyers don't like to do that. I mean, we're trained to look over under every rock and over every hill, and we don't like to go into a trial without anything being unknown.
No surprises.
And that applies if you're a good lawyer, whether you're being paid by the hour or you're on a contingency fee, like in a discrimination case. You're still going to do that degree of due diligence. The problem becomes when you have a client paying you on an hourly basis and it's not a massive dollar amount case, then you as a lawyer need to be flexible enough to understand your client's practical needs. And the client has to also understand that if it turns out in the end that we didn't take the deposition of Mr. X because we decided
To be cheap.
that Mr. A, B, and C were more important.
Yeah, yeah.
And it turns out that Mr. X really had the key information. Unfortunately, that's just the way the cookies crumble. I mean, nobody likes it. I'll tell you what, as a lawyer, if I were to go into a trial and that Mr. X came to testify and I was shocked during his testimony and had very little ability to, cross-examine him and impeach him, I feel horrible on two fronts. I feel horrible for the client, and I feel horrible as a competitor, because that's what a trial is. Mm-hmm. It is a competition. You may have hired your mouthpiece, as they say, but you've also hired a competitor. You've hired, I love this show, Scandal, so you've hired a gladiator, okay? And we don't like to lose.
Well, we're not hiring you to lose.
Well, right. But in these county cases, you have to make smart, practical decisions as to where is money best spent. Where are you likely to get more return for the expenditure? Mm-hmm. And sometimes, through nobody's fault, lawyer or client, the facts turn out to be different. And you overlook something and you talked about ahead of time.
So it's better to handle these things in mediation.
Yes, and any mediator will tell you that. First of all, in Florida, you have to go to mediation before you go to trial. I think most states are going that way if they're not already that way.
Is there ever a case where the lawyers from each side get together and go, this is the way it is, then they go back to their clients and go, here's what we think you should do, kind of thing? Does that happen as well?
That's the way it should work, yeah. I mean, if you've got two lawyers that are willing to treat themselves professionally. Mm-hmm. They have clients to represent, but they can talk professionally. Now, there's certain things we're going to hold back from each other because we're not going to show all our cards. Mm-hmm. But I may acknowledge to another lawyer that, counts 2 and 3 of my client's complaint really aren't our strongest counts. And he may acknowledge to me that on count 1 and 4, my client may have some exposure. We've now made a lot of progress, because now we really know that this case is really about 1 and 4. And he can go to his client and say, look, Mr. Address acknowledges that, 2 and 3 are thrown in there, and he'll argue them if they have to, but that's not really where this case is. It's 1 and 4. And now this lawyer says to his client, and 1 is where I really think you have some exposure. So why don't we try to resolve it this way? Mm-hmm. And before we ever get to mediation, most times, not all the time, most times lawyers will be exchanging numbers. They run them past their clients, mm-hmm. and if there's a counteroffer, they work with their client. Well, they offered $1,000, and we're at $1 million. So should we go down to $999,000, or you want to go down to $900,000 and see if we can get them moving a little bit? And you have these discussions. Mm-hmm. And negotiation is art and science. And if you have two attorneys who truly know what they're doing, they know, as there was a great book from Harvard called Getting to Yes. How could both people get to a decision where They can both walk away saying yes. What does that really mean? It doesn't mean one side won everything.
Well, there was compromise on both sides.
Right, because if one side's going to win everything, the other side's not going to say yes.
Yeah.
And so you're going to go to a trial.
Yeah, there's no yes there.
You're going to have to walk away, both of you, feeling somewhat satisfied and somewhat aggravated. And you want to know something? That's a good settlement. And it's the way legislation should be passed in Congress, everyone. It's the way it was done in the old days.
Well, that was back when people played nice with each other.
They played tough, but they played professional.
Yes.
And Republicans spoke to Democrats, and if the Republicans were in the majority, they got more of what they wanted, but the Democrats got something, otherwise they wouldn't give you their votes. And if the Democrats were in the majority, it worked the other way. Now, forget it, unfortunately.
The problem is they're not looking at what's best for the people.
And that's unfortunate.
Yeah,
So why don't we throw everybody out?
Yeah, I think
Start
so.
all over.
I'm with you.
Okay? But, if you got two lawyers who can deal with each other, that's the way it's going to work before mediation. If you got two lawyers who are going to yell and scream at each other on the phone, and I have some lawyer relationships like that, well, the clients both pay the price for that in fees.
But then the judge is the ultimate decision maker in that type of case because...
Yeah, and then the lawyers start pretending to be somebody they weren't before, in pretrial. And it's amazing. But when you go to mediation, every mediator from small claims court all the way to biggest circuit court case is going to tell you the same thing. This is your chance to settle your case on your own. If you don't do it, 6 people are going to decide this case for you. And your lawyers may try hard as they might to get the 6 best people that you want, but it never happens exactly as you intend. Because you don't know who's going to be on that jury panel. You don't know what order they're going to be called. And you're never going to get the jury you want, even if you watch, I love TV. Even if you watch Bull and you have a jury consultant, okay? You're not going to get that jury that you want. So if you don't want 6 people trying to figure out who's right and who's wrong, the best thing to do is to try as hard as it is to settle it on your own. And very often, a really, really good mediator, and I have seen a good number of them, can settle 95% of the cases in front of them. It can take a whole day. But I have seen mediators work both sides effectively and tough. And then, unfortunately, just like in any other profession or occupation, there are mediators who simply take numbers back and forth to different rooms and shuttle diplomacy, and they don't argue the numbers either way and it's just a number change. I could hire my paralegal to do that. Those are not the mediators you want to use, and as experience, you get to know who's who. And you get to know also who's who in what area of the law, because that often matters if they have some experience in patent law. You want somebody who understands what a utility patent is.
Right.
Because if you have to explain everything from the beginning, you'll be there 5 years.
Yeah.
Okay. But county court civil, you really do need a lawyer. You have to make some compromises. It's tough. We always like it better when we see some way to get attorney's fees, either in a contract or a statutory claim. And the same thing happens in circuit civil, where sometimes you got to say to a client, you're going to pay me X. You really want to do that? And sometimes you're going to have the client say, I would rather pay you. And that's the client you need to sit down with, give them a cup of, well, maybe coffee is not the right thing to give them. Give them a cup of herbal tea. And you have to sit down with and say, I appreciate that. And if you want to send my kids to college, I'm more than happy to let you do it. But there's a legal side and there's a business side.
Sure. Which is the financial aspect of the whole thing. Yeah.
And depending upon who they are. If the businessman, are you businessmen? Are you going to make the decisions from a business
perspective? But there are people who are wired who just have to prove they're right.
And sometimes even those people at a certain point in time will turn to their lawyer and say, I can't believe I spent this much money on you. How come I spent this much money on you? Let's settle this case. and you usually
But
don't say it.
What happens is that becomes your fault then,
Right,
right?
absolutely. But you think to yourself, well, you could have settled this case long ago
Yeah,
for
we
less
didn't
than
have
this,
to do
but,
all
you know,
this. Yeah.
you had to get to that point. Sometimes it happens to everybody in every aspect of life. You got to get to a certain point where you make your own decision. Now, the rabbi, who is my rabbi, who came in a few weeks ago and asked the rabbi, she has a saying. She likes to say sometimes God needs to hit you over the head by a 2x4. Why? Not because he's nasty, but because he sent you the message 5 times already,
And you weren't listening.
and you haven't learned it. So now you're going to get smacked and hurt to learn the message. And it's the same way everywhere.
Yeah, sometimes it's got to hurt.
And, oh my gosh, we only have a few calls for that gift
We've
certificate.
got 8 more minutes.
And I'm about to go into sexual harassment, and we can't have Bulldog calling back just today. Next week, okay. But so I'll just preview sexual harassment. I'm going to mention to you quickly a few cases I've had, and come on, make those phone calls. Jump in there at the last second, like in an auction, and steal that gift certificate. I had a case where my client had a videotape of her having sex with her boss.
One word comes to my mind. Why?
To get evidence.
Sounds like a setup to me.
Well, if it's been happening and she's been complaining, and now the only way to prove it is to prove it, sometimes that's what it takes. Those cases come very, very salacious in a courtroom.
Wow.
I had a case where I call my Spanky case.
Spanky case.
And I keep, my paralegal keeps reminding me, right, Cheryl, that I said I was going to, sometimes clients will often give me a memento of a case.
Okay.
And sometimes I'll buy myself a memento if they don't give it to me. And this was a case where a client was spanked with a paddle and had very bruised buttocks. And those bruises were used to get a lot of money from her former employer in a sexual harassment demand letter before we ever filed suit. There's a lot more facts. Remember, like Paul Harvey said, you gotta hear the rest of the story.
I'm not sure someone's like paddling someone else and getting away with it, though. I mean,
we'll have to hear the rest of the story. But so, I keep saying I'm going to buy my paddle just for my little memento, but I haven't yet. We've had a case with car wash where the uniforms are the same for the men and the women who do all the drying it when the car comes out of the car wash.
okay.
But interestingly, for some reason, the ladies' shorts are usually a size too short for them,
Okay.
and their tops are a size too small for them. But the guys' clothes fit just fine. That sounds suspicious to me.
Yeah. Return customers.
We have had several cases.
I thought they did that for better tips.
If the young lady would like to do that, I don't have a
Right,
problem with
that's
it.
her prerogative.
But if the boss is insisting and providing the uniforms in that way, that's a real problem.
And you're not working at Hooters.
And we have our next contestant for the St. Lucie Draft House gift certificate. And we have John. How can I help you, John?
Hey, I just want to tell you, love your show so far.
Thank you.
I love your station, too. It was easy to remember the phone number.
1590.
My question is, I have a bit of a situation where I kind of injured myself, a toe, and it got infected. And I've been out of work for about 3 weeks, 4 weeks now. My employer, I've been there for over 10 years, and they're very good to me, and I'm a very good producer for them. But I have a situation where I had a back problem. I'm a veteran with some disabilities.
Okay.
But I just got back from my doctor's appointment yesterday, and he told me that I might be needing 3 more back surgeries. I've had a back surgery over a year ago, and I might be needing 3 more. Now, my question is, how do I protect myself when I tell my employer? Because I'm going to go back to work before I get the surgery. It's a minimum of 8 to 10 weeks.
Good question. Glad you asked about it before you went to your employer. Let me ask you a couple quick questions.
Yes.
Does your employer employ more than 50 people?
Oh, yeah.
Good. And in the last year, have you worked more than 1,250 hours?
Yes.
All right. You are covered by the Family and Medical Leave Act.
Correct.
So for any substantial illness or injury, you're entitled to up to 12 weeks off of unpaid leave, or if you have PTO time or something like that, they can make you use it, and then you go to unpaid leave. Your job has to be protected for those 12 weeks as long as you get the doctor's certification. You know, you need to be out 12 weeks, or some doctors say you need to be out 6 weeks.
Correct.
But as long as you're within that 12-week period and you're able to come back, they have to give you back your same job or what is called a substantially equivalent job, and I litigated that phrase in a federal court trial for 2 weeks. Essentially, a substantially equivalent job means that it's roughly the same compensation, the same benefits, the same opportunities for advancement, the same opportunities if there is for bonuses or commissions, the same duties, responsibilities, level of authority, or very close to it. Now, if your employer gives you a problem either allowing you the time off, then you need to either on your own document that you made the request or have a lawyer do it. Or if your employer is wonderful about giving you the time off, and then all of a sudden you get back and you find that you're being written up for this or for that, you need to talk to a lawyer.
Gotcha.
The good employers will understand, they know the Family Medical Leave Act. There is a packet that is prescribed by the federal government. They'll give you a packet, an FMLA packet, which is what you should ask for. There's a page you fill out, your application for leave. There's a doctor's certification page that gets given back to the employer. They approve then or disapprove the leave. If it's approved, you go out, you come back, everything's great. Well, then you have a decent employer. But if at any stage of that process you run into an employer that seems to be giving you a hard time, you need to call a lawyer. That's the best advice I can give you at that point. But yes, given that you've worked there over a year and the right number of hours and employ more than 50 employees, you're protected under the FMLA.
And of course, you do handle those cases.
Oh yes, we handle them quite a bit.
Excellent.
Well, thank you very much, John. And guess what?
Yes.
You do win that gift certificate to St. Lucie Draft House. That was a detailed question, and you actually qualified under the statute, so I think you win the gift certificate. Congratulations.
And of course, you can claim that here at WPSL.
Okay. Thank you very much. I appreciate it.
All right, so you take care and good luck with it, and good luck with your back surgeries. And although it means very little in context, but thank you for your service.
Thank you very much for the information you provided.
Take care. All right, everybody, have a good holiday weekend, and we'll see you next Friday.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.